The not guilty verdict ended the trial, but plenty of questions, legally speaking, remain. We brought in two criminal defense attorneys to be our guides, Darren Kavanoki and Tanya Miller. Join me here in Studio 7. Good to see both of you. Hello. What a weekend makes in this whole thing. I want to talk about the Attorney General's remarks out of Florida in just a little bit. But first, the comments we have heard from prosecutors and the defense. And guys, tell me in my ear, since we went back to the White House, if we have the sound. I think it's important to set up the sound before I ask the question. Do we have the sound from Angela Corey and De La Rionda? Okay. Have you heard the sound from either of them?
I have.
What did you make of that? Because let me just, for folks who don't know what I'm talking about, Angela Corey, who was the person who came in initially and said this should be a murder 2 case, called George Zimmerman a murderer. De La Rionda calls him lucky.
Yes. I mean, she has to believe that. I mean, think about it. She charged him with second-degree murder. She's the prosecutor in this case. She is the one that evaluated this evidence and fully believed, as she should have before she charged it, that he was a murderer. And I think
despite what the jury decided.
Despite what the jury decided, and unfortunately, that's our system. But as the prosecutor, she has to go with the highest charge that she believes she can prove, and she can't, just because she lost the case, now say that she didn't believe that. She believed it then. She believed it now, and I think millions of people believe that as well.
Jump in.
Well, look, the prosecutor has a duty to file charges that they believe they can prove beyond a reasonable doubt at the time that they file the charges.
And then walk back even when the jury says,
yeah, well, absolutely. But what my wondering is where was the evidence? There were strong suspicions, there were notions, there were theories, and I think what the jury verdict spoke to was a fundamental lack of evidence. And if I may, Brooke, the one thing that for me is one of the biggest takeaways in all of this as we're doing the Monday morning quarterbacking on this case, thank God there were cameras in that courtroom.
Why? What do you mean?
Well, because if we just judge this case based on the headlines that a 17-year-old boy was killed and the killer walks free, we'd have a very different view of the case than by watching it day in and day out, seeing how the witnesses actually performed on the stand. We have now a much deeper understanding and are able to have a much different conversation as a nation as a result.
So even if you went into this trial perhaps and had a preconceived notion of what should be based upon just very superficial evidence, you may think one thing, but because of the cameras in the court, that sort of notion deteriorated. You disagree, though.
I agree with the premise that thank God that there were cameras in this courtroom.
But for a much different reason.
For a different reason. Look, the fact that there were cameras in this courtroom allowed the world to really see this evidence.
And man, the world watched.
Absolutely. And the world, many people, not everybody, came to a starkly different conclusion than this jury.
Let me just jump to this because, you know, listen, the major defense attorney here, Mark O'Mara, he's the one who delivered the closing arguments a couple of days ago. He talked to Chris Cuomo on New Day today, and I have to play this sound because he basically told Chris that this was about self-defense. This was not about race. Right. So, says O'Mara, roll it.
We have a lot of conversations to have. I've been an advocate for the fact that black youths in America are not treated well by the criminal justice system, and we need to have that conversation. My fear is that we polarize the conversation because we attach it to a self-defense verdict that they have nothing to do with.
Well, this case became about race in the court of public opinion, but in a court of law, personally, I always viewed Zimmerman as an equal opportunity Budinsky. And I could perhaps even choose stronger words, but I won't.
Thank you.
And from a legal standpoint, the judge also rejected notions that this was about race. Let's remember, the prosecution
couldn't say racial profiling.
Exactly, and they had to go criminal profiling. But obviously, in the court of public opinion, in America, in the world, it became about race, and clearly, we have unaddressed issues that we need to have a frank conversation about.
But I don't think you can blame the media for why people view this case as a race case. I think that you have to look at the evidence in this case. George Zimmerman profiled Trayvon Martin because he was black. He also
profiled him. But there is nuance in this, because when you listen on the 911 call, he only said he was black in response to the dispatcher asking.
Well,
it's a nuance. I'm just pointing it out.
Yeah, but he was the notion is, why is it that a young black male wearing a hoodie is suspicious enough for you to follow him with a gun, confront him, and shoot him dead when he was doing nothing but walking home?
But he had the gun regardless of who's being followed, and these were some of the issues, obviously, that were litigated in the case.
We are going to have an entire half hour at 3 o'clock Eastern Time on precisely sort of some of the points you guys are making, but since you are my legal minds, I want to play some more sound, because this is from a lot of people are perplexed, if I may, by the tone of the defense team during the news conference right after the verdict was read. So let's all be the judge. Roll this.
We needed facts. Unlike what Ms. Corey said, they brought the facts. They didn't. Anybody that watched this trial knew the defense put on the case. We proved George Zimmerman was not guilty.
There was much more to that as well, but I tell you, we went round and around in our editorial meeting talking specifically just about the tone. Did you sense anything? Did he take it a little too...
I think some people viewed it as a little too jovial, a little too backslappy, a little too happy. While in their words they conceded that there were no winners in this case, you definitely got the sense from them that they felt like they were the winners and they were gloating a little bit. I think some people got that impression, whether they intended that or not.
Well, and also, look, there's a reason why jury trials are the ultimate in reality television. There is no pressure like going through the trial and then being in court when the clerk reads those words, you know, we, the jury, in the above entitled action, or whatever it is.
Yeah.
And so the idea that there would be a release of pressure and that might show up like gloating when it's actually relief. And from the defense perspective, they felt like they were fighting the righteous battle, that they had justice on their side, that it was the prosecution's witnesses that, and we all saw this, that the prosecution witnesses became de facto defense witnesses. And from their perspective, what that speaks to is that they believe they're representing an innocent man wrongfully accused. So I don't know that I have too much blame for them in that regard.
Okay, we have to leave it there. It's amazing. I've been on vacation last week. Let me tell you, thank you, but let me tell you, everywhere I went, someone had something to say about this trial. Yes. It has been fascinating every which way. Darren and Tanya, thank you both very, very much.